JRD Enterprises versus Thomas Acquisition Corporation.
Good morning. May it please the Court. Gary Phillips on behalf of the appellant JRD Enterprises. This is an appeal of a order of specific performance on a very complex real estate contract involving $30+ million, which was tried before the court. I'm going to start a little bit in reverse. I want to go back and address the standard of review. And I guess I should thank Judge Sawaya for this, because I was updating my Florida Law Weeklies, and I read on August 6th the Free versus Free decision, which says that if the court first has to make a determination as to whether a contract exists, the standard of review is de novo. Both of us put in our briefs that since this was a case involving specific performance, the standard of review was abuse of discretion. I think the abuse of discretion only occurs if there was a contract to begin with, and you can review it de novo to determine whether there's a contract. I think under either standard, whether it's clear and convincing or greater weight of the evidence, that the trial court committed error. I'm going to start with the trial court's decision, because I think the trial court makes all of the necessary admissions of findings to support our case that there was never any written contract. And the first thing the court said was, and I'm quoting directly from the court on page 421 of the transcript, so if I were to find in this case that there was an intended agreement, there was a meeting of the minds between, say, March 13th and March 29th, and that the March 27th sale of the Reunion property suddenly increased the value of the property dramatically, and that because of that, even though there was an agreement that was not signed, your client, no matter what word he gave, would be allowed to back out of the agreement simply because he had not signed it. And I answered him, I said, yes, that is Florida law. His response was, and that is really the issue in this case. So the judge himself made a determination that there was never a signed agreement. He also said that up until March 27th, I'm quoting, certainly up until March 27th, I believe JRD wanted to close on this property. Yet he went ahead and ordered specific performance on these verbal agreements. I then asked him another question, and because we were having a dialogue during closing argument, and on page 423 of the transcript, I said, and Judge, another rhetorical question, I guess, well, what is the mortgage on this property? Mr. Thomas said it's cross-collateralization. Mr. Davis said, I never heard of that. The court responded, I don't see it anywhere, because there was no requirements, no indication of how these properties would be mortgaged. These were 148 acres, 2 separate parcels. One witness, the plaintiffs testified they were going to be cross-collateralized. There were no cross-collateralized mortgages prepared at this time after the changes occurred in how they verbally agreed to go forward with the transaction. And I responded to the judge. I said, and there is no mortgage. And that was one of the problems. Then the court said, I asked him how he would possibly order specific performance when the closing would occur. And his response was on page 444, well, I wouldn't imagine I would say that. I imagine I would say by December 05. If it goes on and we drag it out for 6 or 8 months, he was coming up with a date, we'll have to see how the appellate court envisions that I straighten it out, seeing if we get to that point. That was the judge's response on how he would handle this if it proceeded to the appellate court. Going through the...
Are you saying there needs to be a written agreement signed by both parties, the same document?
No. What I'm saying is it has to be signed by the party against whom they're seeking to enforce the documents.
That wasn't your initial argument. I mean, your initial quoting of the judge's language, you know, to me, the judge is talking about the lack of a written agreement signed by both parties, one common document.
No,
I mean, he did find that there were documents signed by your client with terms, didn't he?
I don't think he did. I'll tell you what he ordered. His order says, I'm ordering, specifically, the order, if you read it, says, I'm ordering the enforcement of the last draft of the agreement exchanged between the parties.
Right, but didn't he cite the March 2nd notes, I believe, cite an email from your client and signed
No, he
a
didn't.
letter?
No, his order,
Findings of
I'll
fact?
read you the order.
I'm talking about his findings of fact at the end of the trial.
Okay,
I mean, he made a verbal pronouncement as to what he was finding.
I'll go through those as well and show you how they don't relate, and I'll explain why. The March 2nd handwritten notes does not reference clearly enough the agreement that was reached between the parties. All it says, it's just a few lines. It says, keep 9.55 Cahill's note. Stan pay monthly payment to Jim Davis. Note matures May 06. Stan to pay Jim Davis $4.75 million, 2.5 by April 15th, 04, 2.25 by March 12th, 04. Mr. Davis admitted he never made those payments. He never made the March 12th payment. If this is the agreement they were going to enforce, he had breached it. Secondly, it says note matures December 05, 17 million plus or minus note. Note balance increases at 7.5% annual rates to be prorated. Closing Stan pays real estate taxes. Stan is responsible for brokerage fees. Now, it doesn't reference the parcel 12 reunion, the other property. It doesn't set forth the total amount of consideration to be paid. It doesn't even make any requirements on a note or mortgage on how this property is going to be securitized, because the intent here, or when the closings would take place, the intent under this agreement was they were trying to figure out, well, we can't, Mr. Thomas wasn't allowed to assume the mortgage. They said, okay, you can't assume the mortgage, so what are we going to do? They said, well, you keep the title to one, I'll take title to the other, I'll pay you some, I'll continue to pay the note, at some other time I'll pay off the balance. It was so indefinite and uncertain that the court could not possibly enforce this. So that's the March 2nd agreement. With respect to the emails back and forth, first of all, there was never any intent that those be utilized as a contract. The emails, even from Jim Davis, they say, for inclusion in the contract, attached is the takedown schedule. There's always a belief that there would be some type of contract. And counsel's citing to the Electronic Signatures Act is incorrect. That's a three-part act. The first part only deals with the government. It's the Electronic Signature Act of 1996, and that's part one. And it says government services, agency conducted electronic commerce, etc. And that's, set up so that the agency heads can determine what would be right. Like if you go on Sunbiz and you're going to sign up with your corporation online, the agency head can approve that that's acceptable. The second part, which they're relying on, is the Uniform Electronic Transaction Act. And if you read it, you'll see that it really applies to when you're buying things from Amazon, when you're doing online contracts and accepting agreements. And it says that this section, this is subsection 5B, this section applies only to transactions between parties, each of which has agreed to conduct transactions by electronic means. So you have to agree to conduct your transaction by an electronic means.
How many emails went back and forth between the parties on the transaction?
Emails did go back and forth. I don't think that's a contract, though. I don't think that that's an agreement to form a contract to sell a $31 million piece of property when you've been negotiating for over 2 years a 31-page contract. Now, I'm going to explain that in a minute, why I say for 2 years. But so I don't think that they can just say those emails constitute a contract. Nevertheless, even if the court were to think that the emails were somehow a contract, they're still not sufficient enough. And now I'm going to explain to you why I say it went back for 2 years. Mr. Thomas originally had an agreement to buy this same property. The plaintiff, who's seeking specific performance, had an agreement to buy this property before my client ever purchased it. For 1 year, he negotiated with Bobby Ginn to buy the property. He had a letter of understanding. It had goals that they had to meet. And by December of 2002, he said, I don't want to buy the property. So Mr. Ginn sold it to JRD. JRD now buys the property. They do it in a type of an exchange where JRD never received any money, but the consideration was about $20-something million, $29 million or so. 4 months goes by, and they get this is the trial testimony, both plaintiff and defendant, gets a call from the plaintiff. He says, I'm interested in the property. I hear you're holding it for me. But Bobby told me he sold it to you, so you would just hold it for me. I said, what are you talking about? I just had a complicated transaction. I'm not holding it for anybody. So they go through a series of meetings. Ultimately, they sign a letter of intent. 8 months after my client bought it, 8 months after my client was carrying it, paying the interest, the taxes, 8 months later, they sign a letter of intent. And the letter of intent clearly says, this is not binding unless we have a definitive written purchase and sale agreement. Either party can cancel at any time. That's in the letter of intent. They then start exchanging documents. And they basically go through a series of 20 or 30-page contracts, never once having them signed, never once agreeing to them. And the interesting point about this is that Mr. Montgomery is the attorney in Georgia who was representing the plaintiff, Mr. Thomas. Mr. Montgomery testified that I wouldn't let my client send the money that he was supposed to send under that handwritten note until there was a definitive signed purchase and sale agreement. That's his testimony. I wanted that contract signed. So I said, why? Why wouldn't you? Said you'd give it on April 15th. Why didn't you send the money? He said, I wouldn't let him send it because I didn't know how it was going to be collateralized. I wanted some type of secured loan payment. I didn't want him to give up the money and not have a signed agreement. This went on with Mr. Montgomery throughout every single document and every single exchange of emails, right up until March 29th. In their brief, plaintiffs say, we were ready to close. We were ready, willing, and able to close on March 29th. On March 29th, an email was sent from Mr. McAlpin's law firm to Jim Davis's law firm saying, we don't agree with the language on the secured lien concept. We want to change the contract. Right up until March 29th, they were still negotiating the language in the written agreement. Now, this is where I think we can find it's clearly erroneous, even if these emails were to constitute some type of contract, which I don't think they do. Mr. McAlpin, in his closing argument to the trial court, says, Judge, they're all the same, but the one that is referenced in this letter, and I'm going to go through the letter, and the statute of frauds provides an order for an unsigned writing to be incorporated into or utilized as part of a written agreement, then it must be referred to in a signed writing. What is Mr. McAlpin talking about? He's talking about the drafts, these 30-page drafts that were being exchanged. He's saying they're all the same, but if you look at, it's referenced in the unsigned letter, which you should enforce. Now, I mean, in the signed letter, which you should enforce. What does that letter say? And this is the whole basis that the court found that the draft agreement should be enforced. It says, Dear Jim, it's dated March 19th. It's from the attorney in Georgia to the layperson here in Florida, not to his counsel. And they had an agreement that they could communicate throughout the transaction. And it says, I understand that you and Stan have reached an oral agreement. Now, the attorney in Georgia is now admitting it's an oral agreement. He then says, as you know, I have prepared a draft agreement for your and your counsel's review and approval. So he's sending a draft agreement to review and approve it. He says, unfortunately, due to various time constraints, it will not be possible for you and your counsel to review and give such approval today. I understand that you and Stan have agreed to schedule this closing of the purchase and sale of the Parcel 12 tract for March 23, 2004, and that on or before this date, you and he will have executed an agreement relating to the closing and the closing of the Cahill's tract. Then he says, to signify your agreement with the foregoing, sign below. So Jim Davis signs it thinking, yeah, I'm agreeing, my lawyer's going to review the contract and we'll get back to you. They then take this letter, and Mr. Montgomery testifies that that letter incorporated all of the terms of that 31-page draft contract. And by Mr. Davis signing this letter to agree to review with his lawyer, actually signed the contract. And that's how the contract is specifically enforced. By the lawyer writing the letter to the layperson and saying, signify your agreement with this and fax it back to me. It's incredible. So I asked Mr. Montgomery at trial, and he testified as follows. I said, Mr. Montgomery, was it your intention when you sent that letter that it would bind Mr. Davis to the draft agreement when he signed it and sent it back? Yes, absolutely. That's my intention. So he intended, by sending this letter to the layperson down here, to bind him to a 31-page draft contract that he admits his lawyer hadn't even reviewed, that his lawyer was going to have an opportunity to review, and that's what the judge enforced. I'd like to reserve the balance for a rebuttal, if I may.
That'll be fine. You've got a little over 4 minutes.
May it please the Court. My name is Kirk McAlpin from Cushman Morris in Atlanta, and I, with Beth Daniels, represent Thomas Acquisition and Stan Thomas, appellees here and plaintiffs below. The issues are these. Did Judge Stroker, sitting as the finder of fact, properly exercise his discretion in, one, determining that the essential elements of an agreement had been decided upon by the parties? And if so, were those elements, essential elements, memorialized in writing so as to satisfy the statute of frauds? Three, was specific performance the proper remedy for the breach of Jim Davis and JRD Enterprises? We would submit, respectfully, that Judge Stroker acted properly within his discretion in making those findings in the affirmative. We've pretty thoroughly briefed the legal issues here. I'm not going to belabor them again, but I would like to refer to a couple of points and read some points out of the trial court's ruling. First of all, the trial court specifically found, as a matter of fact and law, that the essential terms of the transaction were agreed upon and were memorialized in writing. In his oral ruling, he stated as follows, and I quote, "Both parties were in full agreement on March 23rd as to all the essential elements and terms of their contract, including the price of both parcels, times and method of payment, the closing date of March 29, the legal description of the property, which was never in dispute in this case." Secondly, the trial court specifically found that the items of which JRD now complains that were essential and never agreed upon, the trial court specifically found those were not essential terms to these parties' agreement. And I'll read again from the judge's oral ruling. The court finds that it's only after this event that the defendant's seller began to attempt to insert new terms to complete the contract. Among these were options on the increase in the value of the property. Also a specific...
I think we may have covered this, but I just want to make sure in my mind. All this occurred after that other land transaction had closed that was, astounded everybody, that was very successful. Was it $130-some million?
Actually,
is that kind of correct?
Basically, Your Honor,
right.
What happened was Mr. Davis had expressed to Mr. Montgomery in the days leading up to that transaction that he had knew that it was going to be successful. The press was such that it was anticipated to be successful, and then all the excuses came after that. Non-essential terms, the law is clear, and Judge Stroker also affirmed this. Non-essential terms can be supplied by, 1, a rule of reason, 2, custom and usage, and 3, by extrinsic evidence, which Judge Stroker allowed. Here we've got a situation where the first issue is there a contract? That's not a statute of frauds issue, but the test is similar. And the test is, did the parties agree on the essential elements of their transaction or their agreement. If you find that answer is yes, and it can be an oral contract, then you've got to determine if the statute and frauds is in play, was a writing required? Question there is if a writing is required, what kind of writing do you need? And the courts have said a writing sufficient to satisfy the statute of frauds needs to be one that sets forth the essential elements of the party's agreement in writing, signed by the party to be charged. And the courts have also made it quite clear, going back to Meek versus Briggs, that you can have an aggregation of writings, signed and unsigned. They don't have to be one document sitting out there. The court doesn't have to enforce one document. The court is enforcing an agreement, and it is denying the defendant's defense of the statute of frauds, on which the defendant has the burden of proof.
Respond to opposing counsel's argument that the March 19 letter doesn't do that.
Well, the first thing is about the March 19 letter. From the very beginning of this case, we have only alleged that the March 19 letter was one of a series of documents which set forth the essential elements of the contract. The March 12 email sets forth price, property, description, payment terms. The March 2nd handwritten note sets forth who pays brokerage commissions, who pays real estate taxes, even if those were considered to be essential, which the law doesn't necessarily have to assume they will be. The March 23rd email from Mr. Davis sets forth payment terms again, and who pays the GIN loan and when it's paid. The March 19 letter wasn't even necessary, but it is a document signed in writing by Mr. Davis, and as to which the draft agreement, which didn't change from March 18th, which was the date the draft agreement referred to in the March 19 letter, through the end of the transaction. And it does implicitly incorporate that document. The statute of frauds would say that document is part of the writing signed by the party to be charged, which gets us over the hurdle of the defense of the statute of frauds.
How does it implicitly incorporate the document?
Because it specifically references the unsigned draft agreement. Now, going back to Meeks versus Briggs, parole evidence is admissible to link an unsigned document to a signed document, to explain the implicit reference. Mr. Davis specifically testified that he had received that March 18th document, that draft purchase and sale agreement, on the date that he received the March 19th letter. And there's an email from his lawyer, Sue Ellen Henderson, to Mr. Montgomery saying Mr. Davis now has the draft purchase and sale agreement and is reviewing it. And that predates the March 19th letter. So even if it's necessary, which I wouldn't agree that it is, the statute of frauds would allow the incorporation of that draft purchase and sale agreement by virtue of its implicit reference therein.
Well, the letter talks about an oral agreement.
But see, that's sort of the red herring in a way. The parties can have an oral agreement, even for the sale of land, as long as the essential terms are memorialized in writing somewhere by the party to be charged. Once the statute of frauds is satisfied, then you look to the total agreement. And the total agreement can be a combination of the essential elements, which have to be agreed upon by the parties and have to be in that writing. But then the court can go outside of the oral agreement or the writings to supply the non-essential elements. It can go to parole evidence. The court can easily look to these draft purchase and sale agreements to supply non-essential terms as extrinsic evidence. They just can't look to extrinsic evidence to supply essential terms for either the making of the contract or the statute of frauds. And the court here clearly did not do that. It made a specific factual finding that it did not do that. It made specific credibility determination that it made credibility determinations, much of which Mr. Phillips has just talked about, are Mr. Davis's versions of events. Well, that's not all that was heard at trial, as we all know. And the court is presumed, or at least I won't presume to tell this court what to do, but I think we would all agree that we're entitled to the version of facts which benefit the verdict. If you have any other questions, I'd be happy to address them. Thank you very much.
Judge Griffin, I think you hit on it, that under counsel's theory, if I send a letter enclosing a 30-page purchase and sale agreement to another attorney saying, please acknowledge you received this agreement and let me know when you get back to me on it, and he signs it, all of a sudden that's going to be incorporated into a series of verbal and nonverbal events. We're going to have people rushing into court claiming, I sent them a letter, it references the 60-page document for this $100 million transaction, now I want to enforce it. It just doesn't make sense. The law requires more than that. And Rundell versus Gordon, the Florida Supreme Court case, says that for a memo for a sale of land to be enforceable, it has to show all the essential elements of the contract, including consideration, payment, interest dates due, security. It's all referenced in the Florida Supreme Court.
Well, tick off for me what you contend had not been agreed to.
If you take away the draft agreement, without the draft agreement, there's no security, there's no dates for when interest would become due, there's no agreement on brokerage commissions that would be paid, which was really important because the letter of intent said you will have a separate agreement to pay the brokers.
If you include the draft agreement.
If you include the draft purchase and sale agreement, we could go forward with the closing. If that draft is enforceable.
How is a brokerage agreement an essential element of a contract for sale and purchase between a buyer and a seller of real estate? Isn't that basically a collateral or incidental feature that, and even if it's not particularly agreed upon by the parties, I mean, that's up to the broker to enforce it, not the two parties?
Well, the broker had already made a claim, and my client was a seller, and they made a claim with the seller.
But how can the brokerage agreement be an essential feature of a contract between a buyer and seller of real estate when basically what they need to agree on is the property that's going to be purchased, the legal description, the purchase price, and the essential terms, whether it's going to be a mortgage, contract for deed, or whatever?
Well, in this case,
how is the...
It was a $30 million contract, $1.8 million due to the brokers. The issue wasn't the agreement with the broker, but who was going to pay the broker.
Well, let me ask, and the March 2nd, 04 note signed by both parties say who's going to pay it. Isn't that right?
It does. And then this testimony came out at trial. This was from the broker. It said that his client was going to pay it. And this is from the broker. Jim Davis called me yesterday very frustrated, and this was to his client. He said he talked to you about trading some of his equity for additional lands, but he was adamant about the closing being scheduled for Friday meeting to occur, and this was before the sale occurred. It then goes on to say that I tried to contact you to talk to you about my brokerage commission. You won't call me back. And that's why Jim was concerned. He said, this is a $1.8 million deal. I'm now going to get sued to pay the broker because you agreed in the letter of intent to get it.
But I think Judge Griffin's question was leaving out the attached contract to the unsigned contract to the March 19 letter, what wasn't in other writings. I mean, the broker fee issue wasn't in other writings signed by both parties.
That it was.
Okay.
And one other thing, Judge Sawaya, you asked if this occurred, if this agreement was reached prior to the sale.
I'm talking about a lot of the non-essentials that they were talking about. I mean, there was this huge sale that everybody thought was just, the greatest sale in the history of Florida, and then all of a sudden, the premise, one of the underlying premises of their argument is that that's when your client decided to try and back out and insert these other non-essential elements to try and get out of the deal. It
was actually the plaintiff on March 29th, after that sale occurred, sent the following email. We were still, Mr. Davis was still ready to go forward. He had not terminated. But when on March 29th, they sent an email from Jeff Montgomery, again, the same attorney who handled it, he said, I recognize I'm late to the party, but I do not agree with Sue Ellen on the judgment liens at all. To the extent that Davis is responsible for a judgment lien being imposed on the property, I do not see why he cannot be required to apply all proceeds toward resolving the problem. And he goes on to want to now change the contract again. This was on March 29th. After the sale, he's still trying to negotiate that draft agreement. And Judge Evander, that March 2nd agreement, when it was presented to Mr. Montgomery, he wrote a letter saying, I am now going to put it in a purchase and sale agreement so that we all agree to it. And then he admits later that the parties He even drafted it wrong. He couldn't figure out what the parties meant by the March 2nd letter, and he prepared this draft purchase and sale agreement again, and he had to change it several times to reflect the parties' intent. So I don't think there was ever a writing that could be charged against Mr. Davis to enforce the sale. We believe it should be reversed. Thank you.
Thank you, counsel.